hearing. So that should be starting up here momentarily. Okay, I'm going to go ahead and get everyone checked in. As I call your name, if you could confirm if you do have a name on the screen that name is correct, and then let me know who you're representing here today, whether you're the owner, the applicant, a neighboring property owner, or someone else. If you could let me know as I call your name. So I have Elizabeth Islam. And you'll just need to unmute. Yep.
Sorry, that's me. And I'm owner of adjacent property.
Got it. All right. Welcome. We have the Manley Burke office there. If you could, Tim, just sort of introduce yourself, and then if you would like to introduce the folks in the room or have them introduce themselves, either is fine.
We are representing Donna and Dean Trindell, who own the property to the south. Both of them are down with the flu, so they are not here in the room. I don't intend to call them as witnesses, but they are listening on the phone. With me are witnesses we are prepared to present today, and that's Ron Rothaus, who is known as the Arbor Doctor, Pat Wheatley from Hyde Park Landscaping, and Jonathan Woker from the McBride Dale Clarion Planning Firm.
Got it. Okay. And those names, those were submitted prior to the hearing, correct?
Correct.
Okay. All right. Mr. Zobrist, Kurt Zobrist?
Yes, we are the applicant for the owner, and we are the design and build firm for the project.
Okay, great. Welcome. Kristen Scarpidi?
Christian Scarpidi, but I'm the owner.
Got it. Okay. Welcome. And Andrew Scarpidi.
Correct. Andy Scarpidi, owner.
All right. Welcome. And finally, I see we have Wes Menzel from the City Zoning Department here. Welcome, Wes. All right. So on the applicant owner side, are we expecting anyone else to join us here today?
No, our whole team is here.
Okay, fantastic. Let's get started. So I'm gonna begin by just reading through our hearing script. This will cover the procedure for the hearing, and then we'll jump into it. So this is the November 8th, 2023 session of the Zoning Hearing Examiner docket. Again, my name is David Sturkey. I'll be presiding over the hearing. The case before us today is case number ZH20230156. The purpose of this hearing is to allow applicants, that's at 2830 Ambleside Pl. The purpose of this hearing is to allow applicants and any potential opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any potential opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. Anyone from the public will then have an opportunity to speak after the applicant has presented its case. If the applicant is represented by an attorney, the applicant's attorney may cross-examine any person who has testified at this hearing. If a party of record is represented by an attorney, the attorney for the party of record may present witnesses after the applicant has presented its case and may cross-examine any person who has testified at this hearing. In the event that any party testifies or offers argument in opposition to this application, the applicant shall have the opportunity to rebut that testimony and or argument offered in opposition. After the applicant has been given an opportunity to rebut any testimony and or argument offered in opposition, any attorney for a party of record will have an opportunity to make a closing statement. And then finally, the applicant will have an opportunity to make a closing statement. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties with the Zoom technology, I'll do my best to troubleshoot those on the fly, but to the extent there's some defect that prevents us from me fully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay. Looks like we have someone attempting to join us now, so I'm gonna let them in. I'm gonna go ahead and swear in all of our witnesses now, and I'm gonna do that collectively. So everyone here that intends on providing any testimony, making any comments, asking any questions, really doing anything other than just strictly observing, needs to be sworn in according to the zoning code. And so if you know now that you would like to provide some testimony, I'm going to go ahead and again collectively swear all those people in. So if you can make sure that you are off mute, I need everyone to raise their right hand and to answer out loud.
Mr.
Do you
Stewart,
solemnly? Yes.
I will not be being sworn in because of being counsel.
Yes, correct. If you are providing testimony today and you are not an attorney, please raise your right hand and answer out loud the following question. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Okay, great. Thanks, everyone. Let me see if I can try to make contact. It looks like Thomas Arnold is not connected to audio. Is anyone expecting Thomas Arnold to join us?
Tom is one of our staff. He's just going to be listening to the conversation. Okay. He's not participating.
Okay, fantastic. Thanks. Mr. Zobrist, are you ready to proceed?
Sure.
Okay.
Mr. Turkey, before we begin, can I make a suggestion? I know it's not going to be received well, but we were very close to reaching an agreement between our clients and the Scarpettis, with only some details to be resolved, which we're not capable of resolving immediately. If we get into this hearing now, it's likely to become a very adversarial hearing that doesn't help us in that regard. The opportunity to try and resolve this matter could be unfortunately lost. I think everybody would benefit if we had a short period of time to take a breath and try and get these details resolved. And if that meant putting things off for 2 weeks, I think in the end, that would benefit everybody.
I generally tend to agree, without saying anything about this particular case or these facts. I generally tend to agree that if there is potential for fruitful discussion or compromise, that is often a much more productive route. And so thank you, Mr. Burke, for that. I will have to then, of course, turn it over to the applicants and the owners to get their sense of or their sense on that. And before you do, let me just say that if you were to want to continue this or postpone this hearing to engage in those conversations, what would happen procedurally is I would just pause everything in place. There would be a continuance to allow you enough time to have those discussions. And then if the discussions did not end up with some sort of agreement or compromise, I would just put the hearing back on for a date that you all are comfortable with, and we can just pick up where we left off. And so having said that, so the only downside to a continuance, I guess I'm trying to say, is that you would there would be a delay between when the hearing is actually adjudicated or not. But that can be as short or as long of delay as it takes for you guys to have those conversations. So if you have questions about that, let me know. But otherwise, do you have a response to Mr. Burke's suggestion?
I'd like to confer with our clients on that.
Sure.
I prefer not to do it in the public forum here at this point.
Totally understand. Why don't we take would 5-minute recess, you think, be enough? Okay, let's do a 5-minute recess. You guys can throw yourselves off mute, turn your video off if you'd like for more privacy, and then we will we'll reconvene, let's say at 2:20.
That'd be great.
Okay, so we're in a brief recess. Thanks, everyone. Let's just give the folks at Manley Burke an opportunity to rejoin us here. Okay. Call this back into session. Mr. Zobrist, have you had a chance to consult with your clients?
I have, and would like to just ask a simple question now of Manley Burke, if possible, before making the final decision to postpone or continue. Would that be acceptable?
I think so, yeah, sure.
So we've been very open and transparent on this whole thing and working diligently to respond to requests from neighbors and Manley Burke. And we jumped through hoops to get responses in writing back in agreement for the majority of their request. Can the arbor doctor tell us what the cost of a mat is in the area where we're talking about?
We were in the process of just looking that up. We believe that the maximum cost to protect both that one magnolia that won't be protected by the fence and potentially protect the crepe myrtle in the front, it's a couple of $1,000. And bluntly, Donna has indicated she will pay the cost of the pads.
So essentially, we're in agreement on all your other requests then, because we had agreed to those in writing. So I guess there is no concern then, if I'm understanding this properly.
I think that's right, but we really haven't. Just a few minutes ago, you were concerned that we didn't have details worked out.
I was concerned on the cost of the mat and what we were signing up for.
Right.
But we've issued a formal letter to you and to the record, that's part of the record, to David's office, stating that we are in agreement with the downspout issues, the silt fence issues, the tree doctor monitoring the root trimming and pruning, and so forth. So we've accepted all the terms other than the last minute one that came across about the mats. And if the neighbor's going to pay for the mats, I guess I would say that we're all in agreement on everything.
I think that's right. What I would like to do, because David hasn't seen the email that had the 3 conditions on it, I think we can put that up, or we can email it to David, whichever he prefers. We can share it on the screen, however you want to proceed with that. But that's what you responded to, saying the Scarpettis were agreeable to, correct?
That's correct, because it's a direct reiteration of the letter that we issued back to you guys before that email. So
And David didn't have those yet either, does he?
he does.
So,
He does.
so
Okay.
Tim, I received some attachments from the applicant that I forwarded to you late this morning or this afternoon. So that was another thing I was going to address, just to make sure that everyone had those documents and had a chance to review them. So one suggestion I was going to make, I could put this hearing back on for 1 week from today at the same time to iron out these details. If you guys think there is any ironing that needs to happen, or Mr. Burke, do you have any response in terms of what your clients?
I think we are just about there, but I've got nothing in writing yet that says my client will pay for this, and she will. I'd like to get that reduced to writing. And if you can put this off for a week, that's a very quick turnaround. We can get this finalized, and it will make this a whole lot easier to deal with for everybody. That would give us the opportunity for the doctor to put together the list of the number of pads we're gonna need, the final cost on that. We'll lay that out in the conditions, and we'll lay out in the written conditions that our clients are gonna pay for the pads.
I'll say this, coming into the hearing with a with a clean record and unambiguous documentation is going to streamline the actual process and get you to the finish line, I think, just as quickly as if we were to muddle through it this afternoon. And so just saying that if the timing is a concern, that delaying this a week, I don't think will have any meaningful impact on any timelines, and it'll be a cleaner record. But ultimately,
can write the decision for much more quickly.
That's generally the case. And again, I think this is something that we could bring back before the holiday. But ultimately, it's up to the applicants and the owners. If you all would like to try to piece this together as we go here today, we can do that over the next couple hours. But it's really, I think generally I tend to defer to the applicants and the owners on whether or not we're postponing something. So to Kurt and the Scarpidis, do you?
It's just unfortunate that we have responded quickly to all of these matters since May, when the house was purchased, and we're at the end here when it's been known about forever, and we've provided all documentation with many months of review. So it's just unfortunate of the position where we are of having to postpone here when we've done all the right things. So
Okay, no, you don't have to postpone. That's not what I'm saying. I'm saying if you'd like to postpone, that I don't think it'll be a detriment in terms of the timeline. And we'll provide a cleaner record and an easier hearing. If you'd like to go through it today, please let's go ahead and begin and get started, since we're already at 2:30 here.
Andy and Christian, I lean to you. Do you have time to postpone if we do this next Wednesday on your schedules?
That was just a suggestion. I can do a different day next week. Thursday afternoon, Friday afternoon are also available for me.
Kurt and the rest of the guests, I think we can postpone. My concern, transparently, is continuous delay of the process. And Mr. Sturkey, if you're suggesting that delaying by a week will allow you to make a decision faster because of a clean record, I agree that that's a reasonable request. On the flip side, my concern is that between now and then, that additional requests are made to muddle and to create more complexity than what we've already agreed to today. So my concern is, we've agreed, opposing counsel has submitted to us, the Scarpidis, concerns from their client on Sunday this week. So just again, a couple days ago, we've discussed with Kurt and their team very quickly to try to make sure that all those were addressed. As a side note, verbally, we've been, I think, very amicable and collaborative with the Trindles about wanting to make sure that we have a favorable outcome for everybody. We love the trees.
Looks like we have a little technical difficulty.
And we're now,
Mr. Scarpidi, I'm sorry, you froze there for a minute. You were saying, I think you love the tree. Was the last thing we heard.
love the trees. Understand their concerns and requests, and think that the requests that they've made are very reasonable. We've now documented it for everyone's review. Kurt, I believe, shared his written response with opposing counsel and with the clients yesterday, and there was a delay because an email ended up in a junk mailbox, which maybe not a relevant detail, but these are all things that I feel like we've really pushed hard to try to get clarity to everybody involved over a very short timeline, and with agreement on everything in writing other than the cost of the mats, now knowing that the client, the Trindles are willing to pay for that. I don't see, but I'm very confused why we should not move forward at this point in time.
Okay. Mr. Burke, I'll allow you if you wanted to respond at all, if you think you can help.
I would like the opportunity, and we can do this very quickly. We're going to hold this to the 3 points that have been agreed to in principle. We won't add anything to that. The principle that's going to be, the information that's going to be added to it is a burden on our clients, because they will, in consultation with the arbor doctor, determine how many pads need to be made, need to be provided, and cover the cost of those pads. It will be up to the contractor for the Scarpettis to install the pads. And I'd like to get that kind of detail into writing that we can jointly agree upon and get to you. And I think we could have that submitted by the end of this week. And then whatever day next week works for the Scarpettis, we'll do it and get it done.
So, David, with that being said here today, is today's recording part of the record of our application?
This is part of the hearing. And it will become an official part of the record. Absolutely.
So the verbal
statements,
the verbal issuances of the 3 things we've agreed upon and everything we're talking about, it can't go sideways from that. Is that what you're saying? And if it does, there's record here of that.
there's a record of the representations that Mr. Burke, who is an attorney and officer of the court, has just made to this body. And I think that's about as much as I can say about that. But there certainly will be a record of those statements. Yes. I don't know if we're any closer to a decision here, but I am going to leave this in the hands of the applicants and the owners. Would you like to postpone this matter for 1 week or proceed today?
Andy, I'll speak based upon what you said before. Realizing that we could potentially get to a quicker decision on this, I think we can postpone. We'd like to keep it to a week. Realizing that there's 3 items that we have agreed to, and we're down to just a legal piece of paperwork that ties all those together.
Sure. And let me also be clear about one thing. I still have to review this application and review the standards and the law of the application and make a determination based on that. This continuance is to try to discuss with your neighbors some compromise to eliminate any adverse effects which may have an impact on my decision, but by no means is having universal neighbor support mean that a application is automatically going to be granted. We still have to go through the process and the procedure to review the standards. And so I want to make that clear. Of course, if your neighbors are in favor, that significantly does help applications, and to know that there's not any adverse effects for neighboring property owners is one of the factors I have to consider. So I just want to make that clear before we moved forward.
That's helpful context, Mr. Sturkey. If we're waiting for feedback from me, and also I appreciate the comments from opposing counsel. I think it's reasonable to delay a week, if possible, to Wednesday next week.
Okay. All right. Well, let's do that then. This will be continued in progress. I appreciate both sides' willingness to discuss this further and to try to, iron out any agreements that you all have discussed in the past. And on my end, I will do everything I can to get this decision out to you and get the permitting, if it is ultimately approved, to you before the holiday. So hopefully that helps. And that's, as I said at the beginning, that's generally the time frame. These generally take about 2 weeks, but I'll do everything I can to expedite the decision for you all as a result of this delay.
Thank you. I
Any other
appreciate it.
Sure. Any other questions about the process or procedure here as we move forward? Okay, so we will resend out an invite. It might just be like an updated invitation for the Zoom. And so you should see that all coming in your emails within the next day or two. And is there a particular time? I 2 o'clock is, I think, the earliest that I could do it on the 15th. While we're all here, does that time work for anyone, or is that any conflicts? Okay, great. All right. So you'll be getting an updated invitation for November 15th at 2 o'clock. I will see you all then. We are continued in progress. Thanks again, everyone. Talk to you soon.
Thank you.